Hello everyone. Today we are starting a new chapter which is Competition Act 2002. Right. So of course this prima facie tells us that it is a law which is actually going to govern or regulate competition, right? And competition in India. Now, you might have heard or you might not have heard that there was a law earlier called as MRTP Act. MRTP Act stands for Monopolies Restrictive and Trade Practices Act 1969. Okay. Now, sorry, 1969. Now, the question is, what do we mean by competition? Right. So, the meaning of competition, why competition law is needed, why competition law is needed, why replacement of competition law was done, because as I told you earlier we had a different act, right? Why replacement of competition law? And from exam perspective, the first topic that may be asked in your examination from this particular chapter is objectives. Okay, objectives of competition act. So we have certain objectives. Now this is a file which you'll not be having and you'll not be given. This is just a regular class file. If there is something that you want to note from here, you may. Okay, so the very first thing, ma'am, what do we mean by competition? You can see the image out here. What is it happening? Everyone is fighting with each other. Are we talking about the fight that we had in school, that lemon race, or I will come first in the class, or something like that? No, that was also competition, but that is not the competition which is governed by this particular act, because here we are talking about commercial competition. Here we are talking about the competition between the enterprises. It is concerned with business operating enterprises, right? So there is a person who is doing business and he's competing with his rival firms, right? That is the competition that we're talking about over here. So competition in general is a fight to win something. Here we are talking about a rivalry to win customers over your business rivals, right? So you are trying to attract more and more customers, and if you are able to do that, if you're able to deliver what you want to, if you're able to sell what you want to, then that is what is, you're leading in that competition, right? You're winning that competition. Now, this is in general, and you will never be asked the meaning of competition. Let me tell you first. First of all, okay, so it is basically the process of rivalry between the enterprises. Now, to crack this competition or to win this competition, there are a lot of fair and unfair means adopted by the business enterprises, right? But, before we actually go on there and we unfold what is there in this particular chapter, the first thing that you have to understand over here is competition necessary in the market? Let's say you want to purchase any product, right? It could be any product, right? It could be a soap, it could be a shampoo, it could be a mobile phone, it could be your glasses, whatever it be, right? So supposedly you want to go out and purchase a shampoo. Now, the boys might be very simple with the shampoos or soaps or any beauty products, or like they are like indifferent, right? It doesn't matter which shampoo, we'll just pick up any and we'll wash our hairs. That is what it is meant to. But maybe girls might be a little choosy, or maybe it depends on the age that you are in, right? So, you go to a shop and you asked for shampoo. Now they gave you a particular shampoo which you don't like. You don't like the ingredients put in. You don't like this. You don't like the fragrance or whatever it is, right? It's smelling, right? So you asked for a choice. You said, I don't like this particular shampoo. Please give me another shampoo. And they are like, this is all what we have. Okay, no problem. We'll go to another shop. So you went to other shop and again you asked for a shampoo, and the same shampoo they also gave you. So every time you're going to the next shop, that is the shampoo that you're getting. That means in the entire market there is no choice. And when there is no choice, do you think it is beneficial for the consumers? Well, no. You don't have a choice. There is absolutely no innovation. The same thing is running. If because there is just one company which is producing and selling shampoos. Okay, so that is the only choice that you have. They are also not willing to innovate, they're also not willing to reduce their cost, because whatever they're producing, people are buying it because they don't have a choice, right? Now, if supposedly there are four more manufacturers of shampoo and they also start supplying shampoo, now people have a choice. So they will choose, right? They might have their own preferences. Now they will be, the manufacturers will be like, I should innovate, I should cut down the price, right? I should be more efficient. So this is actually improving the enterprise also, and it is in the best interest of consumers also. So of course, one thing, what is competition should be clear. Then, is competition good or bad? Undoubtedly, competition is good for the economy. Why competition law? Ma'am, we understand that competition is there and competition is good for the economy. But what is the need for any law of competition, right? We don't need any law. See, competition needs to be regulated, or because, as I told you, there could be unfair means also of winning, and there could be fair means also of winning or attracting your customers, or whatever the case be. like let me take you to the very first one. Okay, now here we can see competition is there. There are four sellers who are selling stationery. Okay, there are four sellers who are selling stationery. Or before this, I will tell you another simplified example, right? Because we are just discussing one simple thing, that why do we need competition law? Because the sellers or the persons or the enterprises who are involved may be engaged in some practices which are unfair. Okay. So there are four sellers. I'm not taking this particular example. There's another example which I'm telling you right now. So there are four sellers who are selling stationery, and this is another seller who wants to sell stationery. Okay. So he went to these four shopkeepers who are, let's say, manufacturers. Okay. Or there is one manufacturer. Right? And then there are some wholesalers, four sellers of stationery. Okay, so these are 1, 2, 3, and 4. Now, this is a fifth person who goes to the manufacturer and asks for some stationery, that you supply me also the stationery. I also want to open a shop and sell this, right? Now, there is already some existing competition in this market, which is good, right? And there is going to be some more competition if Mr. 5 also joins as a seller, right? But what happens is, these four sellers, they go to the manufacturer and tells them, please don't supply goods to 5. We will give you 1% extra or something like that. So they do some kind of deal, and they're trying to eliminate, or they're trying to drive out Mr. 5 out of the market by using some unfair means. Don't you think this should not be done? Yes, ma'am, this should not be done. Who is going to stop this? Who is going to see that this is a practice which is anti-competitive in nature? It is somehow reducing the competition, right? Or curbing competition or hindering competition. So this is anti-competitive and should be stopped. Who is going to do that? For that, we need competition law. So competition law earlier also existed, but the competition law that existed earlier was very restrictive. It was only focusing on certain areas, like there shouldn't be any monopoly of any enterprise, right? So it was curbing monopolies and restrictive trade practices. It was not actually promoting competition. It was like, you should not do this, you should not do this. It was like that, right? So when we look at the modern society, there was a need of a modern competition law, and that is when MRTP Act came into picture. Okay, so I will make you write something. It's all written, but still I will make you write something. Okay, so MRTP Act 1969, it was the first enactment and it came on 1st June, effective from 1970. Competition Act 2002 was enacted on 13th January 2003 after recommendations of a committee formed on modern law. And based on these recommendations, MRTP Act was repealed. Was repealed. Okay. So what you'll remember, because you'll be asked a lot of MCQs also. So from MCQs perspective also, we have to prepare ourselves, right? So the first thing that you have to remember is that MRTP Act came into effect on 1st June 1970. Thereafter, government appointed a committee to examine that this is the current law and is there a need to shift to the new law, because this is a law which is actually just curbing monopolies, right, and not promoting competition, right? So what should be the new law which should come according to the modern times, right? So there was a need for a modern competition law, right? So based on the recommendations of that committee, Competition Act 2002 was enacted on 13th January 2003. So you have to remember both these two dates. Okay, both the dates, both these two dates, both the dates, right? Okay, and thereafter it has been amended, and recently also there was an amendment, but you don't have to read everything that is not incorporated in your syllabus yet, so we'll be just beginning. Okay, fine. Okay, so competition. What is competition? Clear. Is competition good or bad? Of course, good. Why competition law? That also I have told you. Why replacement of old competition law? That also I have told you, right? Now we have to go on to the objectives of Competition Act 2002, right? What are the objectives of the act? So there are basically 5 objectives and you have to learn all these 5 objectives. The first one is prevent anti-competitive practices. The second one is promote and sustain competition. So whatever competition is existing, that has to be sustained and there should be promoted to have more competition. Protect the interest of consumers, ensure freedom of trade. See, ensure freedom of trade means what? There are a lot of times when there are so many government policies and restrictions that people are reluctant and not able to do the business that they want to, right? So ensure freedom of trade means maintaining a very good balance basically of law and the opportunities, right? That means it should be single window, very simple to do this, very simple to do that, right? So that is also a part of it. And then there is competition advocacy. What is competition advocacy? You are not supposed to read about competition advocacy, okay? That is not all the sections the section relating to competition advocacy is not included in your syllabus, yet you should know the meaning of competition advocacy. What is competition advocacy? It is about creating awareness. Creating awareness of what? What are the benefits of competition? The benefits of competition do not only extend to the consumers but also to the business enterprises. As the business enterprises scale, right? If they scale, they innovate, they try to cut down the cost, and if there is more competition, they'll do it more, right? If there is more competition on this level, there will be more competition on all the levels. So if I am a wholesaler and I am buying some goods from the manufacturer and selling it to the retailers, the manufacturers also have competition, so they are competing, they're cutting down the cost, and I am getting that particular product at a lower cost, right? So I will also make more profit. So it is a complete chain. Everyone makes good profit, right? If I have more competition and my selling cost is reduced, then my purchase cost is also reduced, right? So eventually there are a lot of things and we will explore them one by one. Okay. So what is competition advocacy? It is an effort by government, right? And it is all about creating awareness amongst the enterprises, amongst the consumers. Like, you must have heard about a very common phrase, jago grahak jago, if you know. It is under Consumer Protection Act, right? We will read about that also, because you need to know the difference between Competition Act and Consumer Protection Act when we are talking about the interest of consumers. So how it is, so one by one I'm going to evaluate these two. I've already told you, and there isn't much to explain in that, but I will explain you all the objectives, and thereafter we will begin with the main content of the chapter. Okay, so the first one, when we talk about prevent anti-competitive practices, right? What are anti-competitive practices? Although I have already given you one example, one or two examples, but here, see, there are 4 sellers of stationery and they have collaborated. They have formed a group. They have formed a group, or you can say they have formed an association. They're all 4 sellers. So it is a group of sellers who have agreed to control the price of the product. It means cartel. I have just given you a simple hint, right? I have not explained you the meaning of cartel yet. I haven't explained you what is anti-competitive agreements, what is abuse of dominant position, etc., etc. Nothing. Okay, just listen to me very carefully and you have a very good idea about the chapter. Okay, so this is actually cartel, about which you'll know in detail later. So what they're doing is, they have decided that no matter what customer comes to us, we will not sell a pen below rupees 25. The same basic simple pen, let's say, I am only able to find out the cap. Let's say a basic simple pen, the cost of which is 2 rupee and is available in the market and was available in the market till date at rupees 2.5, right? Now, suddenly, when I go to buy this particular pen and I ask them the cost, they say it's 25. All the 4 sellers, it's 25. Now, I don't have a choice because I need a pen and I'll have to buy at 25 only. So are they not making huge profits? Is it not anti-competitive? Why is it anti-competitive? Because there was a competition among you 4, and had there been healthy competition, you would have tried to cut down the cost or bring in some innovation or tried some techniques or whatever. So healthy competition is welcomed, is promoted, is in the best interest for the consumers, prima facie. Now you are trying to curb this competition that will not compete with each other. Let's keep it at fixed. Whoever comes will sell it at 25. You don't. Why? Why now there is no need to compete? Because you have kept the price so high that instead of 4 sales, even if you're making 2 sales, you're making more profit than before. Right? So this type of things, or this type of practices, are anti-competitive. We have a beautiful section 3, wherein we read about anti-competitive agreements later. Okay, so this has to be prevented. Okay, and if it is done, then this has to be turned down as void and like things. We'll do that later. For this, you all know that government works through its ministries, right? So Ministry of Corporate Affairs is the ministry which is also responsible for competition law, right? Under this, we have an authority, CCI, which is Competition Commission of India. Under MRTP Act, we had MRTP Commission. Okay, under the previous act, we had MRTP Commission, and now we have Competition Commission of India, that is CCI, and CCI is responsible for all of this. CCI is responsible for overseeing this. CCI is responsible for ensuring freedom of trade, fine, and everything. Okay. Okay. Now, promote and sustain competition. Wow, wonderful case law is there, and it is a recent case law all over in the highlights and everywhere. Many of you might be knowing the facts of the case. I'm not going to get into the facts because here I'm just trying to tell you the aspect of competition. It has a very wide scope. It is absolutely practical and professional, and you can enjoy a lot if you go deep into this particular topic. Okay, now listen to me very carefully. We all know that Google acquired Android, and now 90% of the users that we have are using Android phones, right? So when you're using Android phones, you're also using the apps, right? There are n number of apps which are being developed every day. Now there are two ways to reach the end users, right? If I develop an app today and I want you to install my app, I can provide you the direct link, right? That okay, install this particular app, whatever is the setup, right? I can send you that. Or there can be another option that I am listing my app on the Play Store, right, which is available in Android. Okay, so their listing means I can get the opportunity to reach the masses, right? I get the opportunity to reach the masses. So if I develop an app and I want to reach the masses, Google Play Store is the main distribution channel that is available for me. Okay, so every app eventually, when it is being developed, they approach Google Play Store and they get the listing done over there, right? There's no problem, absolutely no problem, right? Now the problem starts. Just an example. The problem starts that there is an app which gets listed on Google Play Store, and you all know that app has in purchases, right? In-app purchases means that when you go inside the app, you could have a subscription or you could make some purchase. So whatever in-app purchases are being done, it could be, the money could be collected through a lot of payment gateways, right? Now, Google put a condition. What am I writing? Google put a condition that you have to use our billing system only. That is also not a problem. You provide us the billing system, we'll use that billing system only. But for using that billing system, supposedly if I'm collecting payment through any gateway, I have to pay 0.5. But if I'm collecting through Google Play's billing system, I have to pay 2 rupees. Now this is a hefty amount which the Google is charging, and they're putting it as a condition. So are they not abusing? Are they not abusing all the app owners, right? Is it not harsh condition that they're putting on? Well, let's say all the app owners will boycott Google. Can they do that? They cannot. Why? Because it is having a dominant position in that market. There's nobody else available, right? So you want or you don't want, you have to follow it. You have to follow it, right? So this is what this basically relates to our section 4. Our section 4, this was actually relating to section number 3. This is actually relating to section number 4, where we talk about abuse of dominant position, which is again prohibited. Abuse of dominant position, which is again prohibited. Okay. Now, because we started with the point of promote and sustain competition, it is the duty of CCI to see that if had there been another competitor of Google, right, the situation wouldn't have arisen, right? So if there is a lot of competition, there is less chances of establishing dominant position. Dominant position is not bad. Google is enjoying a dominant position. That's not bad. But it may reach to such a situation where they're abusing, they're putting unfair conditions, right? So that is why it is very important not just to sustain the existing competition, but also to promote it. Fine. Then you have to protect the interest of consumers. Now, listen to me very carefully. If I go and buy this particular bottle, when I come home and I fill in the bottle, the water is leaking. I go back to the shopkeeper and I say that you have given me a bottle which is damaged or defective. So please return this product and refund my amount. The person is not ready. I have a remedy under Consumer Protection Act. So whenever consumers are cheated at a very micro level, this or that is happening, then you can go to the consumer forum and seek relief if you're a genuine person. Okay. If you're not genuine, then there is no relief that you'll get over there also. Fine. So that is one. But then when we're talking about Competition Act, it is not about providing remedy to such small consumers. No, it looks at the bigger aspect, at the macro level, and it tries to prevent it. Prevention is better than cure, right? So it is trying to protect the interest of consumers at large. That if this happens, or if this is happening, it is hampering the interest of consumers at large. Probably they don't even know it. So they won't even get to know if this merger is taking place, right? Or we are paying heavy amount, or if this, whatever, there are a lot of mergers, there are a lot of amalgamations, there are a lot of deals, right? There are a lot of acquisitions. They take place and we don't even get to know. Can we be affected with this? Yes, the burden will come to us only. We will be restricted by choices, a lot of things. So Competition Act or CCI is looking at that bigger picture and trying to protect the interest of the consumers at the macro level. Fine. Ensure freedom of trade is something that I've already told you, and competition advocacy is also something that I've already told you. Please write this. Write the heading competition advocacy and write these two lines. Write these two lines. Giving you a moment to write this. If I tell you in general, then Competition Act is also known as antitrust laws. I don't know how many of you know this or how many of you don't know this, but it is also antitrust laws as it is known in other countries also. Right? Why? Because when I'm talking about cartels, right, such type of business which form and create a monopoly, that was known as trust, and the laws against such agreement, that is antitrust. I am just telling you for your information. You don't need to write it. You won't be asked this, right? So law that takes care of unfair situations in the market under Competition Act is Competition Act, and the institution which is actually overseeing the functions and functioning of all the market players, that is the regulator under Competition Act, which is CCI, Competition Commission of India, right? Okay. Now, meaning of competition. Competition is defined as economic rivalry between market players to attract customers. This is competition. Competition law is defined as those government measures that affect the behavior of enterprises and the structure of industry. We have competition policy. What are competition policy? We have competition policy, set of policies, liberalized trade policy, relaxed FDI, a lot of things. Competition law is basically to prevent anti-competitive agreements, right? MRTP was the first enactment, effective from 1st June 1970. And government formed a committee, and based on the recommendations of the committee, Competition Act was enacted on 13th January 2003. Right. This is basically the structure of Competition Act. So we have 9 chapters in total, and there is a chapter 8A. We don't have to read all the sections. Whatever relevant sections we have to read, we will be reading, and I'll also mark you the section numbers which are important over the period, as and when we study, you'll get to know, right, which section numbers should I learn, right? So this is the overall structure. And when we talk about objective of Competition Act, then these are the 5 objectives. Okay, competition advocacy, ensure freedom of trade, protect interest of consumers, promote and sustain competition, and prevent anti-competitive practices. Fine. So the act extends to whole of India. It is called as Competition Act, and it shall come into force on the date as may be notified in official gazette. All the basic information which you don't need to actually learn. Right, the dates you need to learn, I've already told you that from examination perspective, MCQs, and the objective you need to learn. Right, so far this is the case. Okay, now okay. Okay, so continuing with our chapter of Competition Act 2002, now we're starting with the main chapter, I would say, because if we talk about the substantive, if we talk about the main provisions of this particular act, it is four. It concentrates on four areas. Section 3, which is about anti-competitive agreements. Then we have Section 4, which actually talks about abuse of dominant position. Then we have section 5, which talks about combinations, and thereafter combinations are regulated under section 6. And we have something called as competition advocacy, about which we don't have to read in detail. Okay, so you basically need to know the meaning of competition advocacy that we've already discussed, right? Other than that, you don't have to read the provisions in detail. It is contained in section 49. Okay, now so we will start with anti-competitive agreements. But when I say anti-competitive agreements, we cannot proceed to read this particular topic before we actually know the meaning of two terms. What are the two terms? One is agreement and the other one is enterprise. So one by one, we will actually see both the definitions, right? Okay. So the first definition is agreement. What is an agreement? Usually when we talk about the term agreement, it is what image do we or how do we imagine it? Okay, there must be something formal. There are two people who are actually signing to things, agreeing to things, right? So that is what an agreement is. And if we breach this agreement, we'll be dragged to the court. There will be a breach of so that is what image that we perceive of the term agreement. However, agreement is very, very, very simple. I say tomorrow you have a class, you say. That means maybe you're not happy, but you're nodding and you're agreeing to this. This is an agreement. So we agreed that tomorrow we'll have a class, right? It is as simple as that. So agreement is nothing but it is a sort of understanding, or it is a sort of arrangement that two persons, two enterprises, a person and an enterprise, three persons, three enterprises, a combination of them, they have agreed to. It need not be in writing. It can be oral also, and it need not be specifically expressly said. It can be implied also, implied in a way that you just, or you wink, or you say, whatever it is, right? So all your actions, the definition of agreement is basically very, very wide, and any type of communication in any form is agreement. If there is an understanding, there is an agreement, it need not be in writing, it need not be oral, it need not be enforceable by law. Okay, so what is agreement? It is an understanding oblique arrangement. It may be in writing or oral, need not be enforceable by law. I hope you understand what is enforceability by law. See, unenforceable contracts are also there, about which you have read. You have if I talk and if I simply tell you what is enforceable and what is not enforceable, it is all about the legal intention of binding the other person through court, right? Like Mr. X comes up to a shopkeeper. Okay, so here we have 4-5 shopkeepers are here, right? And we all 5 shopkeepers are selling stationery. Okay, now Mr. X, he is a customer, or let's say we are 5 wholesalers of stationery and he is a retailer. So he comes up to one shop with a proposal, and he is proposing that I have a deal for you. I want this much quantity of printers and at this price, or I'll be doing this, I'll be doing that. So he has come up with some proposal to the first shopkeeper. Now the other 4 shopkeepers are somehow looking at this, and they are trying to tell by not using words or not communicating verbally, but through some expressions and trying to nod. And they all agreed to one thing: not to deal with Mr. X for XYZ reason. Okay, that we'll be discussing later. We'll be seeing the factors and everything later, right? But for XYZ reason, they're not willing to enter into a contract or accept his proposal or give him a fair chance. Now, this will be called as an agreement or not? Of course, it will be called as an agreement under Competition Act. But is it enforceable by law? Maybe they did not have the intention to legally bind him. Even if they agreed, and the next day again Mr. X came and the shopkeeper dealt with him. He accepted the proposal. The other 4 shopkeepers cannot actually drag him to the court and say, no, we entered into an agreement. So it is not something which is enforceable by law. Right, so it need not be enforceable by law, but you are agreeing to something, you are reaching an understanding, you're reaching an agreement, right? So it is an agreement. It is an agreement. Now we have agreements of 2 kinds. We have horizontal agreements, the example of which I already told you, and we have vertical agreements also. So horizontal agreements are between the same level of production chain. We are all wholesalers. We have manufacturer, we have wholesaler, we have retailer, right? We have distributor, we have a lot of people involved in this entire chain, right? If a manufacturer is entering into an agreement with a wholesaler, with a distributor, this is something which is vertical. That means they are in the different level of production chain, right? But here we are like competitors. Right, so you're entering into an agreement with your rival. What can you do? You can do a lot of things, and a lot of things that you're doing together could be anti-competitive, like this one. What you're doing over here, you are not letting somebody enter into the market. Right, you're not letting somebody enter into the market. Maybe you have a potential threat that today he's buying goods from us, tomorrow he might open a shop right beside us, and he might also, so whatever for reason you're trying to, this is anti-competitive, so such type of agreement should not happen. Okay, one by one we will analyze, and we will get to section number 3, and we'll see what it is, right? Okay, but I hope you have understood the meaning of agreement, what exactly agreement is. Okay, before we go in further, we will also understand what an enterprise is, and thereafter we will move to section 3. Okay, so enterprise. What is an enterprise? Enterprise could be any person. What do you mean by person? Person means an individual, person is HF, person is company, person is firm, person is AOP, person is BOI, person is cooperative society, any other body corporate, any other artificial judicial person. So this is something that you already know. Although we have the definition of person also in this act, right? But you know what person is. So enterprise is any person or department of government, or department of government. So government department is also included in the definition of enterprise. So if government department is entering into any agreement with any such person which is considered as anti-competitive, then action will be taken against that government department also. So in the definition of enterprise, government department is also included. Now, what they're doing, if the definition is only this much, then I am also a person, I am also an enterprise. Right? Now, person or department of government which are actually engaged in what? Engaged in any process of the entire supply production chain. That is, if you're engaged in producing, you're producing goods, or maybe you are a person who is actually storing goods, you are supplying goods, right? You are involved in the distribution channel, okay, or somehow you're acquiring goods or services. So both these are included. Or you might also be engaged in investment or acquiring, holding, underwriting of securities. Securities means shares, debentures, other securities, everything. So if you are a person who is actually engaged in acquiring securities, who is engaged in providing providing the service of underwriting securities, then you are again an enterprise. If you are involved in any of this process, you are an enterprise. If you are involved in any of this process, then you are also an enterprise. Okay. Now you may be acquiring, holding, or doing this underwriting directly or through subsidiary. This subsidiary might be located at your location, or it might be located at some other location also. So whether such subsidiary, I hope you're writing this with me, is located at same place or different, it doesn't matter. Now, one thing that you have to remember very, very, very importantly in this particular definition is that although government departments are included, but those government departments which are rendering sovereign functions of government, they will not be included. Like we have atomic energy, we have currency, we have defense, we have space. So you have to remember these four, and you have to write this in the definition when you're doing this. Okay, so they are not included. That means if they are stopping somebody else to enter into this competition, enter into this, or they're creating a barrier, or they're doing whatever, it is about country's defense, it is about currency, they have full right, they have full freedom to stop them, right? So there will be dominance, there might be abuse also, there might be anti-competitive agreements also, whatever you may say, because we cannot let competition come in these fields. Okay, so atomic energy, currency, defense, space, sovereign functions of government, we cannot let competition act, play a role in these sector, right? So they are excluded from the definition of enterprise. Okay, so even if they are entering into any such agreement, they are not prima facie enterprise, so that will not be validated against them. Okay, so there won't be any case against such type of departments. Okay, so I hope this is clear. Fine, but we need to read the definition also. We will go back and we will see the definitions. Acquisition will do later. Cartel I'll tell you. Chairperson is nothing. Consumer also I'll tell you. Enterprise, here we come. So it means a person or a department of government. Firstly, you have to learn this definition from examination perspective. Okay, so it will be very easy for you if you're writing with me, if you're prompting with me. By the end of the class, half your definition will be already learned. It is for all the students, and if you're very bright student, of course you'll be through your definition like this. Okay, so it means a person or department of government. It means a person or department of government engaged in any activity. Activity means you are a profession or occupation, it doesn't matter, relating to production, storage, supply, distribution, acquisition, or control of articles or goods, or provision of services. Okay, now, or investment or business of Acquiring, holding, underwriting. Let me be very specific, although this is something which is very obvious. But there was a student once who asked me a query that, ma'am, if I am a person and I'm buying shares, then am I an enterprise? No, my dear, you are not an enterprise. Here we are talking about the persons who are doing some profession, occupation, who are doing some business, right? So if you are involved in the business of providing underwriting services, or you're an investment company, right? So your core business is to acquire shares, sell shares. So if you're doing that, then also you are an enterprise. Then you will be called as an enterprise. Okay. You might be doing this directly. You might be doing this directly or through any subsidiary or any division which may be located at the same place or at different place, right? So far whatever I have highlighted, except from this, whatever I've highlighted, please keep this in mind. And but does not include any activity of the government relating to the sovereign functions, including atomic energy, currency, defense, and space. Got it? So this is that you need to learn by heart. Whatever I have highlighted are the keywords which must be learned by you all. Okay. So coming back to our next part, section 3, anti-competitive agreements. What do you mean by an agreement? Agreement or understanding, arrangement or understanding, or any action in concert. What is action in concert? The action that you are doing together. Supposedly one person is pulling a string and all of them join and pulls a string. So this is pulling a string. You're doing this action together. You're doing an action in concert. So even if you don't reach to an oral understanding or through expression, but you're doing something together, that means you have an understanding. That means it is an arrangement. That it is an action in concert. That means it is an agreement, right? So any arrangement, any understanding, any action in concert, whether or not it is formal or in writing, or whether or not it is intended to be enforceable by legal proceedings. So you might not have an intention to legally bind the other person through this agreement, yet it will be called as an agreement only. Okay. Now there are two types of agreements: vertical agreements that are entered amongst the persons at different stages of production and distribution chain, and horizontal are entered between the enterprises which are competitors or which are doing the same line of trade. Okay, fine. So these are the two types of agreements, vertical and horizontal. You must know its meaning. You must be able to write it. Now we will begin. So we have agreements. If they create or are likely to create appreciable adverse effect on competition, that is AAEC. Agreements which create an appreciable adverse effect on competition, they are void. Orders including penalty may be passed by CCI. Inquiry may be done on alleged contravention. So if somebody puts an allegation that these four persons are entering into an agreement and they're not letting us compete with them, they're creating a barrier in competition. This is something which is affecting the competition severely. So we have an authority, CCI, Competition Commission of India, which will look into the matter, and if the contravention is found to be true, then they will pass orders that you cannot do this agreement, or the penalty may be imposed, and like things. Okay. So section 3 tells us that if there is any agreement which is likely to create or which creates an appreciable adverse effect on competition, then it is going to be void. Fine. Now, how do we know that, ma'am, this is the agreement which this is a vertical agreement, or this is a horizontal agreement which people have entered into? Now, is it creating appreciable adverse effect or not? Is it not? If they create an appreciable adverse effect on competition, they are called anti-competitive agreements. Okay. And are void. If they create appreciable adverse effect on competition, they are called as anti-competitive agreements and are void. Plus, this may happen. So I hope you have got the picture. This is how it works. Now the question is, how do we know that this is an agreement that they have entered into, and is it anti-competitive or is it not anti-competitive? We need to understand, right? So point number 1, let me write it this way. It will be determined, or write it this way, an agreement is anti-competitive or not will be determined by CCI considering certain factors. Considering certain factors like creation of barrier to new entrants, etc. Okay, I am not writing all the factors over here because this is separately, we'll be doing it, right? One thing at a time. Secondly, there are 4 horizontal agreements recognized by Act as anti-competitive. So these 4 agreements, if you're entering into, they are presumed to be anti-competitive. You don't need to see, you don't need to analyze, you don't need to examine. If you're entering into any such agreement, it is presumed to be anti-competitive. It is presumed to be anti-competitive. What are these 4? I'm writing in very short. If I write over here, then you'll be like, okay, ma'am, if we write this way in exam, will we get marks? No, you'll not get marks. Let me elaborate a bit. Directly or indirectly determine or limit sale or purchase price. Sale or purchase price. I am writing in short, my dear. Everything is written in the book, so I cannot write everything over here. Limit or control output, development, etc. Output, development, etc. Divide area or bid rigging. Okay, so one by one we are going to discuss all these 4 points. What are they? They are horizontal agreements. Horizontal agreements means what? Persons who are competitors are actually coming together and they are agreeing to certain thing, right? So these are 4 types of horizontal agreements. There could be more, but they need to be evaluated. But these 4 types mentioned in the act are presumed to have adverse effect on competition, and they're presumed to be anti-competitive, presumed to be void, right? In which the first one is determining sale or purchase price, or basically it could be like fixing the prices, right? Fixing the prices means what? Now, supposedly there are 5 shopkeepers. Okay. If I am a customer, I walk up to the first shop and I want a particular pen, right? They're charging a hefty amount of 100 rupees for this particular pen. I would be like, no, this pen's worth is not more than 5 or 10 rupees. Why are you charging such high amount? They'll be like, no, this is the price that we are charging. If you don't like it, you may go. We go to the other shop. Again, they are going to charge the same price, 100 rupees. Is it in the best interest of consumers? Somehow, these 5 shopkeepers have communicated with each other, have reached to an understanding that we are not going to sell this particular pen below 100 rupees. Now, if as a customer I go to any shop, I'm going to get it at 100 only. So now I don't have that choice, right? There is no competition amongst these people, right? And it is harmful for the entire market. For it is not in the best interest of the consumers, because now we have to pay 95 rupees more for a particular pen. And how are these shopkeepers getting the benefit? Why not? If they wouldn't have agreed, they would be selling this particular pen for 5 rupees. So many pens have to be sold to get to this particular profit, which they're earning by just selling one pen, right? And everyone needs pens, so the people will have to take it, because they have limited options only, and all those limited options have actually collaborated with each other, and it is also called as forming a cartel. Forming a cartel. When a group of people come together and they have reached to an understanding, it is like they have formed a cartel. I'll explain you the exact meaning of cartel a little later. Okay, but first, these 4 types of agreements, right? So is it anti-competitive? Of course, it is anti-competitive, ma'am. As we're hearing, we are understanding this. So when you're understanding this, you have to understand that it is presumed anti-competitive, and any such agreement wherein you are determining the sale price, that this is going to be the sale price or this is going to be the purchase price, whether you're doing it directly or you're doing it indirectly, it's anti-competitive. So any agreement entered into between enterprises or association of enterprises, including cartels, engaged in identical or similar or trade goods. So here we are talking about horizontal agreements. Horizontal agreements. So any horizontal agreement which directly or indirectly determines purchase or sale price, that means you're somehow fixing the prices, right? So this is anti-competitive. The next one is when you are limiting or controlling production. Now this happens in a lot of cases. We have heard about such funny cases also, where suddenly the prices of onions shoot up, right? Suddenly the prices of tomatoes are shooting up, right? What happens? The people who are the suppliers of onions, or who are producing onions, right, who are supplying onions, let's take, they have entered into an agreement that we are not going to supply onion. What will happen is the demand for onions will rise. If I'm not getting onions at 3 places, then my paying capacity automatically increases, because there is demand and I'm not getting it. There is shortage. So when I reach the 4th shop and I ask, do you have onions? They'll say, yes, we have onions, but I'll give you at 500 per kg. Okay, fine, you give it. I'm not getting it anywhere, right? So when there is shortage of a particular product, the demand increases, and thereby you can charge higher prices, right? So that is why a lot of people might enter into an agreement to limit the supply, that we're not going to supply this to the market. And if we don't supply this to the market, there will be demand and we'll be able to make more profits. But this is not good for the market. Healthy competition is essential for the market, right? It benefits the consumers, and in a way it benefits the market players also. Okay, who are the market players? The shopkeepers, right? In general sense. Okay, so if you're entering into any such agreement, right? If you're entering into any such agreement, it is void. Okay, fine. Next is, if you are dividing the market, sharing the market or source of production by way of allocation of geographical area of the market. So you are saying this particular area is yours and this is mine, right? Now we are not going to interfere in each other. That means that particular person could come into this market and therefore could create healthy competition, but you're not allowing that person to come here. So you're charging whatever you want to, they're charging whatever they want to, and the consumers over the on of that particular area, they don't have a choice. The consumers of your area, they don't have a choice. This is highly anti-competitive. How can you divide the area? Let them grow, let them be efficient, let them bring in more innovation, let them be doing cost efficiency, cost cutting. That is what is healthy competition, and that is what blossoms the market and indirectly directly benefits the consumers, right? And the last one is bid rigging. Bid rigging means unfair bidding. You understand what bidding is? What is bidding? Like supposedly government has released a tender that government needs 500 printers. Okay, and now these are 5 stationery shops which come to know about government's tender. Right now they will apply and quote their prices that this configuration printer we can provide to you at this particular price. At this, right? Now everyone gives a quote, and based on the quotes, based on the quality, whatever they have referred, government finalizes the tender with the lowest price, and they look at other factors also, but then they are going to give that. Okay, so if I quote that I am going to give you a printer for 20,000, the other person quotes I'm going to give the same printer at 18,000, the other person is quoting I'm going to give the printer at 21,000. So government will analyze, and maybe this 18,000 person will win. Now, what they decided amongst each other is we all will quote it at 30,000. Or only you quote at 30,000 will not participate in the bidding. The government doesn't have a choice. That is the process government will follow. Right? So government has to give this tender at 30,000. Now they're making huge profits. So they'll share the profits amongst themselves. Right? So bid rigging means any agreement in which you are eliminating or reducing competition for bids, or you are manipulating the process of bidding, right? How do you do that? You're submitting identical bids. Everyone is saying 30,000, 30,000, 30,000, right? Agreements as to who shall submit the lowest bid, or you are agreeing voluntarily. They have inflated the bid. They have said, okay, we will bid like 1 lakh, because if they don't bid, there might be suspicion, why are they not bidding, right? So they are participating in that bidding process, but they are highly inflating their bids, because ultimately their focus is that the tender should go to this particular person and will share the profit. Or agreements not to bid against each other, right? Or calculating the prices in the same manner, right? Or designating that you are going to be the bid winner this time, the next time I'll be there, next time you'll be there. What is this happening? Is it some child play which is happening or taking place over here? No. So these 4 types of horizontal agreements are presumed to be anti-competitive and are void. You have to remember this, my dear. You have to remember this. Now we come to vertical agreements. Now vertical agreements, what are the vertical agreements? We have tie-in arrangement, we have exclusive supply, exclusive distribution, refusal to deal. Tie-in arrangement, I think the definition is here only. It's written here only. It's not written as a separate point. Okay. Yes. Then we have resale price maintenance. Okay. So these are vertical agreements which we are talking about. Vertical agreements. Here we are talking about vertical agreements. Now, vertical agreements are not presumed to be anti-competitive. They have to be evaluated on the factors and checked that whether it is creating an appreciable adverse effect on competition or not. If it is creating an appreciable adverse effect on competition, then it's going to be considered as void. Right? Okay. So let's now see vertical agreements. So the first one, tie-in arrangement. Okay. Now what is tie-in arrangement? What do you do? What is tying? Right? When you're tying someone, right? So tying occurs basically when customers are wanting or wishing to buy a particular product. Okay, so you want this particular product, but you're being bound by the condition that if you want to buy this product, you have to buy some other product also. That means they are somehow forced to buy another product if they want to buy this particular product. Okay, now, this could be in situations anti competitive. It could not be anti competitive also. Like if you want to buy a car comes along with the tires. So is it like this is also a tie-in arrangement, right? You can buy a car without tires because tire is a separate marketable product also, right? But it comes with a car. So this is something which is not anti-competitive, right? So if you're bundling your product with some other product, then that is tying an arrangement, right? But supposedly there is a case law written over here. Now let me tell you, there are certain case laws on all the topics which are written over here, all the types of vertical agreements that we're talking about: tie-in arrangement, exclusive supply, exclusive distribution, refusal to sale, and resale price maintenance. Okay, now these case laws are only kind of examples, so refer them as only examples and only for understanding. These are not supposed to be learned by you. Okay, fine, ma'am. Okay, now as the example over here, what is given that we're a gas distributor. Supposedly, I'm a gas distributor, and the consumer comes to me and they want to buy, of course, they want to get a gas connection, right? Now if they want to get a gas connection, I am tying them with the condition that if you want this connection, you have to buy a gas stove from us. So this is a precondition to get that domestic cooking gas connection. Do you think it's valid? It isn't anti-competitive. Now all those companies which are actually buying gas stove will not be able to sell it, so you are driving somehow the existing competitors out of the market. Why and how? Because you are putting in such a condition. Everyone wants a gas connection, right? Without the connection they cannot work, so they want, this is something which is mandatory, and if they want a gas connection, they cannot go somewhere else to buy a gas stove because you have put that as a condition, right? So this is called as tie-in arrangement. So what you have to remember over here is just the definition, or it's actually the meaning. What is tie-in arrangement? Agreement which requires a purchaser as a condition of such purchase to purchase some other goods. So if you want to purchase this good, you have to purchase some other goods. That is what tie-in arrangement is. Okay. So if you want to a toy, you have to take the battery also. So these are baseless agreements. Okay. Now the next one is exclusive supply agreement. Exclusive supply agreement. Now there is an example also given over here. There is a case law also which is given at the end. But before that, you have to understand the meaning of exclusive supply agreement, right? Here what is happening? You're restricting the purchaser. See, I will first take you through the case law, okay? Then you will understand this better. See, here what is happening is there is a manufacturer who asks a dealer not to deal in similar products of its competitors directly or indirectly and discontinue the supply on the ground that dealer also deals in product of suppliers competitors. That means there has to be, see, students are usually confused between 2 points, okay, or rather between all these 3 points: exclusive supply agreement, exclusive distribution agreement, and refusal to deal. Okay, so one by one, I'll explain you and tell you exactly what it means. Basically, if we are talking about exclusive supply, the person is trying to tell that you have to be exclusively my supplier only. Okay, that means you will supply or you will sell my goods only. Supposedly, I open a shop and I enter into an agreement. I have purchased certain goods of company A, and the customers there, few customers demand the products of company B also. So, should I not have the liberty in general to buy that goods also and to sell that also, right? So, just on this ground, should the supply be discontinued? Again, I would say when we talk about actual market, when we talk about practical conditions and situations, there are cases when such exclusivity is a part of an agreement and it's not considered as anti competitive based on the factors and everything. So, there are exclusive agreements which are entered into. These are not presumed to be anti competitive, they have to be evaluated, they have to be analyzed, right? But what actually exclusive supply is, that you are restricting, you're restricting what, restricting in any manner the purchaser in the course of his trade from acquiring or otherwise dealing in any goods other than those of the seller. Here purchaser means the person who is purchasing goods from you. Okay, so supposedly you are a wholesaler and then there is a retailer. Okay, so he's purchasing goods from you, but you are putting in such a condition that if you are acquiring my goods, then you are not supposed to deal in with the goods of any other seller. That means you are going to be exclusively my supplier. I am supplying the goods to you. You're not supposed to get it from anyone else. Okay. Then comes your exclusive distribution agreement. It is exclusively a distributor in one particular area. So there is a supply, there's a manufacturer, and he appoints a distributor in one area for reselling his goods, right? He's not allowing any other person to enter into the market. Is it not creation of barriers of new entrants? What are they trying to tell is that exclusively you are my distributor for this particular area. That means he's putting a restriction on that person that you can sell only in this area. You cannot sell outside this territory. Right? Like we have a lot of franchisees which get open, like Zepto, Blinkit, or whatever, right? So they have they have a designated area. Okay, that is this particular radius of 3 kilometers is your area. So all the orders which come in this area, you have to supply them. You cannot supply outside, right? So this is like exclusively giving distribution. Now, at times it is okay, at times it might not be okay. If it is effective, if it is adversely affecting competition, then such type of agreements may not be okay. Then comes your refusal to deal. Refusal to deal is a very broad thing, although we are free to choose who we want to do business with, but then there should be a fair criteria and there should be no conspiracy or boycott. Okay, example, if we have A who supplies, let's say, cement to builder X, builder Y. Okay, then there is builder Z who enters and goes to A, and they enter into some agreement, and A denies or stops supplying cement to builder X. That means he refused to now deal with X. Is it fair? What are they trying to do? They are somehow trying to eliminate builder X from the market, because probably A is the one who supplies cement to the entire industry. That is what is available, right? So if you refuse to deal with that particular person, that means you are driving an existing competitor out of the market, right? So why are you doing that? Maybe you have certain agenda for doing that. And if it is affecting the competition, maybe builder X is trying to create a monopoly and they have entered into a competition and they will refuse to deal with all other builders. Mr. A will supply cement to only builder Z. So this is something which is not acceptable, right? So it could turn out to be anti-competitive. So that is refusal to deal. And then we have resale price maintenance. Resale price maintenance has to be understood in two ways. One, the concept of MRP, which we all know. right? That if I am manufacturing a product, I will probably write MRP, that is the maximum retail price at which it can be sold, is 100 rupees, so that unnecessarily what happens, there is no price variation. If I am selling the goods, supposedly we don't have MRP on many products like these, right? So if I'm wearing this particular cloth which does not come under any brand name, and somebody has bought it for say 1000, the other person can sell it for 1500, the other person can sell it for 3000, somebody else can sell it for 7000. It doesn't matter. If there is a buyer who's ready and willing to purchase, the seller can sell it. Now what is happening, the same product, if I have got it for 7000 and I see somewhere somebody is selling it at only 1000, I'll be highly devastated that what is it happening, why have I paid such hefty amount for something which is available at such a lower cost, right? So I'll be a little disappointed. So in such situations, what we have is the MRP, which can be fixed, and it is in most of the products and the packages, right? So this is one concept, that you are trying to maintain the resale price. Okay. Now this is usually done in certain cases. There is another concept which has to be understood, is that even in such cases like this one, there could be a lot of persons buying at different prices. So the seller could put a condition that, okay, I am providing you the goods, this particular good, at 500 rupees, and you have to sell it, or you can sell it not below 700. Why? Just to maintain that consistency. You cannot sell it below 700. Now people can sell it for 700, 800, whatever, just to maintain that brand value, that this particular type of good should not be available at such a lower cost, right? So these are the two things which go parallelly. It is all about maintaining the resale price. So if somebody is buying the goods from me, I want to ensure that when this particular goods is resold, is sold to somebody else, it has to be sold at a particular price, right? So the producer is imposing a fixed or a minimum price or a maximum price, right? So they also set a price for which the product should be sold at a retail level, right? So this is how it works. Basically, resale price maintenance is not much about MRP. It is much about the other concept which I have told you. Okay. So if they are entering into such an agreement that, okay, I am giving it to you and you have to sell it at you have to sell it at 700 only, or you have to sell it at 1000 only. Now everybody is selling it at 1000 only, then there is no competition, there is no healthy competition, because the resellers or the retailers, they're not competing with each other, they're all chilled and relaxed. Okay, I have to sell it for, it is for 1000. You want to take it, take it. You don't want to take it, go to the next shop, there also you'll get it at 1000 only, right? So resale price maintenance in such sense, or in such parlance, it could be anti-competitive. Fine. Okay. Now there are case laws which of course you can read. That's just for your reference. I have given you a lot of examples. You're not supposed to learn it, you're not supposed to even know it. Okay. Now, there is one more thing which you must remember. Okay. Supposedly that I have a copyright. I have done something, there is a patent in my name or whatever, and somebody is trying to use it. Can I not put a restriction on that particular person? Can I not refuse him that, no, you cannot buy this good and you cannot sell it? Of course I can. So there are certain rights which have been conferred upon any person under Copyright Act, under Patents Act, under Trade and Merchandise Marks Act, Geographical Indication Act, Designs Act, Semiconductors Act. Now, under all these acts, whatever rights have been conferred, to protect these rights, to stop somebody from infringing, I am free to impose conditions or reasonable conditions upon them. And if that reasonable condition somehow results in any such agreement, then that is not going to be considered as anti-competitive, because it is out of purview of section 3. So section 3 does not apply, it is not applicable on any such agreement which is entered into to protect my right. Okay, this is a very, very small point, although I have written it in points, so it is in elaborated form, but this can anytime, if asked, it can be in the form of MCQ only, right? So this is a very small point, but of course you have to keep this in mind. I hope that's clear. Good.